So in today's video, we'll look at evidence of character as well as examination of witnesses. So on evidence of character, we'll look at when your good character can help you and where your bad character can destroy your defense. Then on examination of witnesses, we'll look at the few stages and we'll also go through the rules around leading questions, refreshing of memory, and the rule against narrative. So now we have to look at evidence of character. And before we go any further, we need to first understand what the term character means. So character simply refers to a person's reputation in the community and how they're generally perceived by the people who know them. A good example of this can be if a person in a neighborhood is known to be honest, reliable, that's their good character. But if that person is known to be short-tempered, to get into fights easily, that's their bad character. Now, why does this matter in court? Courts have to decide if this person's reputation or behavior is relevant to what they're deciding today. That's when it matters. So as such, admissibility of character evidence is governed by the basic rules of relevance. So if the person's character is relevant in what the court is deciding, that's when it can be admissible. So now we'll get to look at character in civil cases. So the general rule is that in civil cases, character is rarely relevant. Courts are focused on the facts in dispute, like who breached the contract, who caused the accident, and who defended whom, and not on whether the party is generally a good or a bad person. However, character can become relevant in three specific situations. The first one is where character is directly an issue. The second is where character is relevant fact. And the third is character as a collateral fact. So the first situation is where character is directly an issue, or where character is the fact in issue. So sometimes the very nature of the claim puts a party's character at the center of the dispute. So an example of this can be in defamation cases. So for example, if a newspaper publishes an article calling someone a thief and dishonest person, and that person sues for defamation, so the defendant might argue that what we said is true, and here's the evidence to prove the person's bad character, that they are a thief and they are dishonest. So in that scenario, character is not a side issue, it is the fact in issue, it is the main issue. So the plaintiff's character is directly in dispute. So this was seen in the case of Kakongo versus Zambia Publishing. The second situation is where character is a relevant fact. So even if character isn't the main issue, it might be a relevant fact from which the fact in issue can be inferred. So an example of this can be, let's say, an employer is suing an employee for stealing from the company. So the employer can now adduce evidence showing that the employee was fired from 3 other jobs for stealing. So in that case, that evidence can be admitted, not because they are judging their general character, but because it's a relevant fact that makes it more likely that they committed the act in question, which is stealing from the company. So cases on this are Anat Shiwe versus Zambia Airways, as well as the case of O'Brien versus Chief Constable of South Wales. So the third situation is character as a collateral fact. So when a party chooses to testify as a witness in a civil proceedings, their character becomes relevant as a collateral issue, specifically regarding their credibility. So this was seen in the case of Hales versus Kerr. A plaintiff suing a barber for negligence was cross-examined on his own character. But in this case, the court addressed the extent to which such cross-examination was permissible when character was not the main issue, but it went to credibility. So an example of this can be, let's say you're suing someone for a car accident. You take the stand, and then the other side knows that you're convicted of perjury 3 years ago. That conviction can be put to you, not because it proves you caused an accident, but because it goes to whether the court should believe what you're saying in the present case, what you're saying now. So now that we have discussed the evidence of character in civil cases, we can now look at evidence of character in criminal cases. So the character of the accused is much more carefully regulated, and there's a distinction between good and bad character. So we start with the accused's bad character.
So the basic principle is that an accused is always entitled to adduce evidence of their own good character. So this is because, one, it gives rise to an inference that they are less likely to have committed the offense, and two, it bolsters their credibility as a witness. If they testify, the jury is more likely to believe them. So an example is James is charged with, let's say, fraud. He's worked at the same company for 20 years, has an impeccable record, is a community leader, and has no prior convictions. He can call colleagues and community members to testify his good reputation for honesty and integrity. So the jury may think, does this really look like someone who can commit fraud?
Now that we have established that evidence of good character is admissible in criminal cases, we can now look at what kind of evidence of good character is allowed. So here we have the case of Ara versus Roton. So in this case, it was established that good character evidence must be about general reputation in the community, not about specific good acts. So the difference is that, let's say an accused calls a witness, and the witness says, in my community, the accused is known as an honest person and a peaceful person. So in that instance, it's allowed because it's showing the general reputation of the accused. What is not allowed is showing specific acts of kindness. Let's say, for example, the accused had donated 5,000 kwacha to a charity that helped this person do what. Pointing at specific acts of kindness is not allowed. So when it comes to good character evidence, we're talking about the reputation, that is the general view, and not the highlight reel of nice things the accused has done. Okay, so now we can look at the accused's bad character, and where section 157 of the Criminal Procedure Code comes in. So the general rule is protective, meaning an accused who gives evidence cannot be cross-examined on their previous convictions or other offenses or bad character, unless there are certain exceptions. So think about why this protection exists. So if a person is charged with theft today, and the judge or the jury hears they were convicted of theft 3 times before, they might convict not because of the current evidence, but because they assume the person is just a repeat offender. So the law tries to ensure each case is judged on its own facts. So that's where section 157 of the Criminal Procedure Code comes in order to protect people to be convicted just based on their past convictions. So let's break down section 57 of the CPC. So it states that a person charged and called as a witness shall not be asked, and if asked, shall not be required to answer any question tending to show that he has committed or been convicted of or been charged with any offense other than that wherewith he is charged or is of bad character. So what this means is that if you are called as a witness as an accused person, you're protected from questions about your past offenses or bad character. But there are 3 exceptions that can destroy this shield. So the first exception is similar facts evidence. So here it states that unless proof that he has been committed or been convicted of such an offense is admissible to show that he is guilty of the offense now charged. So what this means is that if the past conviction is directly relevant to proving guilt, in this case, the shield fails. So an example is, let's say a person is charged with running a drug trafficking organization. He was convicted of exactly the same type of operations maybe 5 years ago. So that conviction is relevant because it shows a specific pattern that makes it more likely that he is doing it again. So in this instance, the shield fails. But let's say if the person is charged with fraud, and his only previous conviction is for speeding, so that past conviction tells nothing about fraud. So the shield holds, meaning you can be protected. So a case on this is Maxwell versus DPP. So this case established that the judge has a discretion to exclude previous conviction evidence, even where it technically falls within an exception, if its prejudicial effect outweighs its probative value. And also in the case of DPP versus Boardman. So in this case, the accused was charged with homosexual offenses against young students. So evidence from several different complainants describing similar circumstances was admitted.
So the House of the Lords held similar fact evidence is admissible when its probative value establishing guilt is so strong that it is not outweighed by its prejudicial effect. So the similarity must be striking, not merely general. So the third exception deals with evidence against the co-accused. So a practical example of this can be where two people are charged with, let's say, robbery. A says it wasn't my idea, it was all B's fault, it's B who does everything. So when A says that, he has just given evidence against his co-accused. So now this gives a chance for B to apply to cross-examine A on his previous bad character. So this is because A has become in effect a prosecution witness against B. So meaning B deserves the opportunity to undermine A's credibility in the same way the defense could undermine any prosecution witness. So it's like A has switched sides from being the defendants to the prosecution when they point to his co-accused. Then the case of this is Maddox v. Taylor. So this case defined what giving evidence against the co-accused means. So the test is, does the evidence support the prosecution's case against the co-accused, or does it undermine the co-accused defense in any material way? So if the answer is yes, then the co-accused can apply to cross-examine on bad character.